Hi to everyone. We are going to be discussing Medicaid for couples today. What happens when both spouses need care? I'm going to go through some concepts and we'll hold questions to the end. As Liz said, there's a Q&A box at the bottom. If a question requires too much detail or too much back and forth, I'll let you know and we can always handle that separately. You can always send an email and we can let you know if it's something that's going to require a consultation or if it's something that is a quick answer, we can point you to a reference point. So I want to start by saying that a lot of the information that we're going to be giving today is very detailed and it is something that will be different for every person. So I'm going to throw a bunch of concepts out and give you some ideas, but none of this should be taken as legal advice. And as my mom, Nancy Burner, who founded this firm 25 years ago, still says to clients and has always said, don't try this at home. A lot of these things are really legal work that needs the advice of an attorney to make sure it's done properly and without creating a larger issue than you had to start with. So there's my disclaimer, and I'm going to get going. So specifically when I speak today, I'm going to be talking about individuals that need long-term care Medicaid. So I'm talking about those that need a nursing facility and need Medicaid to cover the cost of care, or those that need home care through the Medicaid long-term care program. So those are the two types of Medicaid that we are referring to. I'm not referring to individuals that need Medicaid as their primary insurer. Most of the people we're talking about are what we call dual eligibles who have Medicare and Medicaid and are using Medicaid for their long-term care purposes. So every year, the Department of Health the state puts out the updated numbers for the amount of assets and income that an individual or a couple can have in their name when applying for Medicaid in order to be eligible. This year, for a single individual, it's $904 worth of income per month, and that includes a $20 disregard for being disabled, blind, or aged. And also for assets, it's $15,900. So that is your assets in your name, and that does not count retirement accounts. So if you have an IRA, a 403B, a 401k, any of these tax-deferred retirement accounts, you can have those in addition to the $15,900 that you're allowed to have in your name. As a couple, those numbers change. You might think that that should just be doubled because it's two people, but it isn't. So if you're a couple, you're allowed to have $1,211 in income per month. That includes the $20 disregard again, just like with a single person. And for assets, you can jointly have $23,400. And again, retirement accounts are separate and apart from that, tax-deferred retirement accounts. If one person needs care, we're able to take the assets, transfer it to the individual who doesn't need care, and subject, based on the county you're in, to certain contribution or payback requirements, the individual that needs the care can receive it under those single person numbers that I told you, the $904 of income and the $15,900 in assets, while the spouse retains the additional assets above the $15,900. But if both spouses need care, and let's say they have $100,000 between the two of them, you now have the issue that they're only allowed to have $23,400, and there are lookbacks and penalties for transferring assets. And so that's what we're really going to get into today, because when you're talking about Medicaid for both spouses, you're talking about often how to protect assets when you don't have that ever important exempt transfer to a spouse. So first I'm going to run through some ideas, assuming that both spouses need a nursing home. And then we can talk about home care subsequent to that and some of the care considerations when both individuals are at home and in need of long-term care through the Medicaid program. So first, what is a look back? So if you want Medicaid to pay for your nursing home care, Medicaid goes back 5 years from the date that you want them to start covering the care, and they look at what assets you gave away, you or your spouse gave away over the course of those 5 years for an uncompensated value. So what does that mean? So if I bought myself a new car, if I bought myself clothing, if I went out to extravagant dinners, that's okay. I was compensated for the spending of those funds. An uncompensated transfer, the ones that trigger a penalty for Medicaid purposes, can be thought of as gifts. So I gave $10,000 to my niece. I bought my niece a car. I went on vacation, and it was okay that I paid for myself, but I spent $10,000 on my niece joining me, and I shouldn't have given her that gift. That is the presumption that Medicaid has, that you gave this money away, these uncompensated transfers, in order to qualify for Medicaid, and therefore they're going to charge a penalty. Now, it depends exactly what county you're in, but let's use the round number of approximately $13,000. So for every $13,000 you've given away, again, it's going to fluctuate based on county. For every $13,000 you give away, that's about a 1-month penalty. So it's 1 month that Medicaid will not cover the cost of care. And so you want to make sure that there aren't uncompensated transfers coming up when Medicaid does this 5-year review, so that there isn't a penalty. What can you do if somebody didn't plan? So we have the couple where they both need nursing care and they have assets in their name and they didn't do any advance protection. Well, this is where I make my plug to make sure that in advance of this time, you have a comprehensive power of attorney that the spouses have signed over to someone other than each other, which could mean they had each other and then a successor, be it a child, a friend, or other family member. And that agent under the power of attorney, if done properly, can effectuate a lot of these transfers. So that's a really important planning tool, even if you don't want to do any advanced Medicaid planning, that you have that power of attorney in place in case something needs to be done at the last minute. There are certain exempt transfers. So I already mentioned the spouse. You can transfer assets to a spouse and there is no transfer. So we like to do that, but now both spouses need care, we can't do that. There's 2 sets of exempt transfers. The first is for the homestead. So for your primary residence, for your home. So you can transfer without penalty to a spouse, a child who's blind, disabled, or under the age of 21, a sibling of yours who has an equity interest in the home. Say you have 2 sisters who own the home together and one of them is still there. If they're living in the home for a year before the other one needs a nursing facility and they have an equity interest in the home, then they are an exempt transfer. Or a child who resided in the home at least 2 years prior to needing a nursing home. That's what we call the caretaker child. The caretaker child exemption is an assumption that because this child was living in the home with the parents for 2 or more years prior to institutionalization, that them doing so kept mom and dad out of the facility. So this is a really important one, especially if it's a family home where some of the adult children are living with mom and dad. We use the caretaker child exemption quite a bit. Again, not something you want to effectuate that transfer on your own. You do want an attorney involved because there are tax considerations and other considerations to the exact way that that is done. But the transfers of the caretaker child is incredibly helpful. Other assets other than the primary residence can again be transferred to the spouse, to a blind or disabled child, or a trust for that child, or any other disabled person who's under 65 years old, a trust for the benefit of that person under 65 years old if they're not your child. But these are sole benefit trusts. And again, you're going to want to get proper advice on those because there are paybacks to Medicaid in certain circumstances to get to that beneficiary. So there are other transfers available. But let's say these two spouses don't have the availability to transfer assets to any of these exempt cases. Well, then we get into what were the transfers for. So there's two sets of transfers. There are transfers that were made prior to needing the assistance over the course of the last 5 years. And there's transfers that are made at the time somebody needs the facility that we're intentionally making in order to make the loan. For those prior transfers, let's say you gave $10,000 to your niece and you gave it to her, you were feeling well, you didn't have any major ailments, you were just thinking, well, she's just graduated school and she's getting her life started and I want to give her something, and so I'm going to give her $10,000 to get on her way. You can argue to Medicaid and rebut the presumption that you did it for the purpose of applying for Medicaid. You can argue this was done for a different reason. I didn't give her $10,000 so that I could go on Medicaid one day. I gave her $10,000 because I wanted to give her a gift, and I had given that same gift to my 5 other nieces and nephews, or whatever it may be. And the circumstances of the gifting is really going to matter in that case. So you can argue that. You can also have a return of a gift. So if your niece still has that $10,000, she can return it, undo the penalty period. And that's something that we use sometimes as well. Again, not every plan is going to be different and is going to be very fact specific. So there's also spend downs that we do. So again, we're in a situation where you have 2 individuals. They both need Medicaid. They have more in assets than the $23,400 that they're allowed to have. And we're trying to figure out what to do. Well, we're going to ask, did you prepay a funeral? Because both individuals can have prepaid funeral contracts of whatever amount their funeral is going to cost them. I don't just mean a plot, I mean an actual contract to pay for the funeral, and they can prepay it as long as it is an irrevocable prepaid funeral contract. And that can be an asset that they have in addition to their other assets, and it is a viable spend down for Medicaid purposes. They can also pay attorney's fees. So to put these plans in place and to protect assets, there's often fees associated with that, and that can be paid out of the individual's assets as well. Then we get down to a base number of, we are over by X amount of dollars, over the $23,900 by X amount of dollars. What do we do now? We've run out of exempt transfers. We've run out of spend downs that we can make, and we just have too much money. What do we do? Now, obviously, one option is you just spend all the money, and once on the cost of the facility, when the money runs out, you can go on Medicaid. But rather, what many people want to do is some planning to protect some of that money and pass it on to whomever they were going to give it to at death, be it a child, another family member, a friend. And that's where we get into what we call promissory note planning. Now, I'm going to share my screen and put up a chart. I think the chart should make it a little bit easier to understand the concept that I'm talking about. But again, this goes into the don't try this at home category. So we are going to deal with, let's say, an individual. Just one moment. Okay. So we have an individual, and let's say they, I'm sorry, not an individual, a couple. And let's say that they have $23,900, but then they have $100,000 extra, and we couldn't spend it down. We couldn't give it away anywhere that was exempt, and so we're stuck with this $100,000 overage. Well, you see here that on the top left is the couple. They've got the $100,000. They can give that money over, and if you look over into this loan area and the gift area, they give that $100,000 away. So they still have $23,900 in their name. They give away the $100,000 where they're extra. Part of that $100,000 is determined to be a gift, and that remains protected and nobody can touch it. And the other part of that money that's given away is a loan. And we do an actuarially sound promissory note that allows for that loan to be to a family member. So let's simplify it and say that 2 spouses have one child, they give all $100,000 to the child. Part of it is a gift. But we just said that if you give a gift within 5 years of needing a facility, that creates a penalty. So what we have is a situation where this gift creates a penalty, and then the loan and the calculation is done at the time based on a lot of different factors. The loan payments go back to the couple, and when you add together what the loan payments are monthly, plus the Social Security, the pension, the required minimum distributions, whatever sources of income that couple has, when you add that together, all of that put together pays the private pay rate at the facility during the Medicaid penalty. So at the end of this, the gift is protected, and we used to call it half loaf because in a lot of situations, it was about half of the money that was protected. But that's really going to depend on how much income is coming in and what the facility is going to cost in this private pay time. So the gift is protected at the end of this. The loan ends up being fully paid back. The income on a monthly rate has gone to the facility to pay for the care. And then at the end of that penalty, the person is on Medicaid and they're only contributing their income to the facility, which is at that point, the loan payments will be finished, but their Social Security, their pension, their required minimum distributions, whatever it is. So this is how the promissory note planning works. Now, this is also the kind of planning we do for a single person who doesn't have a spouse to transfer assets to, who is over-resourced and needs a nursing facility. We just have to use the same plan when it's a couple. So let's say that the penalty period that's assessed here is, a 4-month penalty, as an example. It'll be 2 months for each spouse. So one spouse has a 2-month penalty and the other spouse has a 2-month penalty, because you can't double penalize them. So you can't say there's a 4-month penalty here, it's 4 months for each, and that ends up being an 8-month penalty. That wouldn't be fair. So the penalty period gets attributed to both spouses. So that is how promissory note planning works. Again, for when both couples need care, and also when an individual who doesn't have a spouse needs care. Scenario 2, or the other type of Medicaid that we're going to talk about, is community Medicaid. Now, as of today, March 4th, 2021, there is not a penalty period being assessed, and there isn't a look back being implemented for home care Medicaid. So if you transfer your assets in the month of March and you apply for Medicaid in the month of April, they are not assessing a penalty. Now, that being said, the law did change last April, and it was supposed to go into effect in October, that anything that you transfer after October 1st will be subject to a penalty period on the home care side, similar to that as the nursing home side. However, instead of a 5-year look back, it will be a 2.5-year look back. It will only ever go back to October 1st of 2020. So it's not quite 2.5 years yet. But because of COVID, that has not yet been implemented. So we don't currently have a look back, and the direction from Department of Health of New York State is that after October 1st, you weren't supposed to be transferring assets, but we're not looking at whether or not you did. Now, that's not to say that they won't look down the line when this is implemented, when the COVID emergency is over. We're unclear on exactly how that is going to unfold. So again, one more reason why these aren't things you should be doing at home. There's a lot of information that goes into advising you as to the proper way to move forward. But once that 2.5-year look back is imposed, we are going to have to start using that type of promissory note planning when there is a couple that both need care. But for the time being, we can transfer the assets to a trust or to a family member or to a loved one, however works in the particular situation, so that both spouses can be eligible for home care. Now that gets them down to that $23,900 number, which is the amount of assets they can have in their name. What about the income? So I said that with a nursing home, all of the income goes to the facility when that penalty is over, and Medicaid's paying the balance. In a home care setting, you can't give all your income over, because then how would you pay your monthly bills? How would you pay your mortgage, your rent, your maintenance, your electric bills, your cable bills, all of the things, your food, your clothing, all the things you pay for when you're living in a private home? You're going to still need to pay for those things, because in the end, Medicaid is health insurance. It is not a source of payment for your regular bills and expenses. That's an important thing to remember throughout all of this. So you will, once, let's say somebody were to apply, a couple were to apply now, they would then get enrolled into a managed long-term care plan, who would do an assessment to determine how many hours of care they will be awarded. Now, this is important. You have to coordinate the care. So if you have a single person and Medicaid determines, or the managed long-term care plan determines that they need 8 hours of care, well, that's easy. 8 hours a day, they'll get the care and it will be set up. But what happens when you have two individuals in the home and they both need 8 hours of care? Well, then what happens? Well, there's not going to be two aides in the home. So you're not going to have two individuals. Likely what's going to happen is, if both spouses need 4 hours of care, then cumulatively the household will have somebody there for 8 hours. And each spouse is supposed to have their 4 hours of help. Now, many times a home health aide who's in the home may do little things to assist the other person that they were not assigned to. However, by the statute, they're supposed to only be assisting the individual that they are assigned those hours to. So each spouse will get their own set of care, and it will be cumulative on top of each other, not duplicative. For the excess income, it goes into a pooled income trust. So again, for a single person, if you're allowed $904 worth of income, any income you have coming in, Social Security, pension, required minimum distribution, rental income from a property that maybe you have in a trust, whatever it may be, that income comes in, and the excess over the 904 goes into a pooled income trust. Then the money in that pooled income trust can be used to pay the bills and expenses. So it can pay all those things I was saying: your rent, your mortgage, your maintenance, your food, your new home furnishings, your clothing, whatever it is that that individual needs. It's a type of supplemental needs trust where that money can be used for their benefit only. When you have two spouses, we very often say you don't need two pooled income trusts. Now, it's going to depend on which pooled income trust company you go with, who you decide to use, and what their internal rules are, and how they interpret the federal and the state mandates that govern them. And you'll figure out, based on how much income each spouse has, what makes the most sense. But generally speaking, you will have one pooled income trust, for example, for both spouses, and the excess income for both will go into that amount. And again, just to recap, we're talking about everything over $1,211 will go into that pooled income trust on a monthly basis, and then be used to pay the bills and expenses. Now, some of the reason that we, in some cases, have to use two pooled trusts where each spouse has one is if the individual trust company is not willing to split the household bills, and you want to make sure that one spouse's income is not going to waste. They're not just going to pay the bills in the one individual's name. So let's say spouse one has the pooled trust in their name, and spouse one and spouse two's excess income is going in there, and all the bills are in spouse one's name, except for, three of them. Well, then that pool trust, you have to make sure that they're willing to pay those three bills that are in spouse two's name, even though the trust is in spouse one's name. And so that's going to be very important to know in advance when choosing a pooled income trust, if you are going to put both spouses' income in one trust. The other thing that you want to find out in advance from the pool trust company is, how do they handle it when the individual, the spouse who had the pooled income trust in their name, when that individual dies? leaving behind spouse 2, but the trust isn't in spouse 2's name. What if there's $2,000 left in that trust? What do they do? In some instances, we have pooled income trusts that are willing to roll that excess $2,000 over into a new trust in the second survivor spouse's name. Whereas other trusts say that the money that's in the trust that was in the name of the first to die spouse is lost to the trust. And again, that's going to be a difference in how the individual trust company interprets the federal and state laws that govern them. And their interpretation is what is going to be important in that case. So if you do have spouses that are applying for care, those are the important things to look at as to whether or not there should be one or two pooled income trusts. That is the kind of bulk of everything. So I threw out a lot of concepts there, right? How do we protect assets? How do we protect income? What kind of care will come into the home when both people need care? And if you're in a situation where you or a loved one may need this kind of care down the line, again, the most important thing is to plan early and to continually have your plan reviewed. I say this time and time again because laws periodically change. As we've seen in the last 12 months, the Medicaid laws regarding look back, though not implemented, have changed, as well as the power of attorney law has changed. And so you're going to want to make sure that whatever estate planning documents for Medicaid Asset Protection Plan is in place, that it still makes sense based on updated situation for the individual, as well as an updated situation for the laws that have changed. Do we have any questions, Liz?
We do have a few questions. First question is it still true that Medicaid does not recognize domestic partnership and only counts the Medicaid partner's income?
Correct. The domestic partner does not have spouse status in Medicaid world, for better or for worse. So in some cases, you would want there to be a spouse, right? I talked about all those exempt transfers. You throw the money over to the spouse and then the other individual can go on care. But you also don't have the downside, which is being a legally responsible relative or being held to these different income and asset standards based on being two.
Thank you, Britt. Next question. Medicaid ADL requirement has increased to 4.
So I believe what this person is referring to is separate from what we discussed today. But when we determine the level of care that an individual will receive, when the new law was changed to put the 2.5-year look back on community Medicaid, it also changed the threshold requirement for determining who needs care and doesn't need care. If you need assistance with physical maneuvering of 3 or more activities of daily living, then you can qualify for Medicaid home care under the new rule. If you need supervisory assistance with 2 or more activities of daily living, and you have a diagnosis of dementia or Alzheimer's, then you can receive community Medicaid long-term care through the Managed Long-Term Care Program. This is another part of the law that has been signed and is in effect, but is not yet implemented. And we are currently in a comment period where proposed regulations have been put out, but nothing is finalized yet. And the comment period ends in about 10 days, and then we will see what happens next with the Department of Health. But none of that has actually changed yet.
Thank you, Britt. Next question. Any news on the treatment of pooled income trust under the new community Medicaid changes?
That's a good question. So whoever asked that one has been studying up. So the answer is no new news. And the concern for others involved and listening is that right now, if you put assets in a pooled income trust because you're at home on community Medicaid, at your death, the money that's left in the trust goes to the charity that runs the trust. So if you from month to month have a little extra in the trust, it will accumulate and you can use it in a subsequent month, but it needs to be used before your date of death. There is a concern, and this is being addressed with the Department of Health by the Bar Association. There is a concern that if there's a 2.5-year look back, that any money left at the end of the month in a pooled income trust will be considered an uncompensated transfer and could potentially jeopardize an individual's eligibility to receive care in the following month, because now there's a look back for uncompensated transfers. It is unclear how that's going to play out, and we're fighting our hardest to try and prove that that should not be done and that it's not feasible, and check that on a monthly basis and come up with a workable solution for individuals. But it is something to keep an eye on. So I just want to thank everybody for joining us today. I know that sometimes this could be some dense information, but we're happy to provide it to you. And I look forward to coming to you with the next webinar. So thank you so much for joining us, and try and enjoy this beautiful day. It looks like the sun's out.